Good afternoon, everybody. This afternoon's proceedings will be transmitted on the live link, but only after a 15-minute delay. Those with mobile telephones may use them to report what they hear in the hearing room, but only after 15 minutes have elapsed since the event that they're reporting. They may not be used for recording or photography. Yes.
Thank you, sir. Just a couple of matters to clear up from the morning session. Firstly, in relation to the document 0749712, which was referenced to the Gold Group meeting number 3 on the 12th of February 2004, Mr. Mitchell, I think you said that such matters would be referred to the Legal Services Department potentially, and we can see there at the bottom of the list of persons present, somebody from the DLS is in fact present at the Gold Group meeting. Do you accept that?
Yes.
And so were they able to give some kind of briefing in relation to the legal framework that would surround such matters as we addressed in the evidence earlier today?
I couldn't comment. I think that's perhaps a question for the Directorate Legal Services. Unfortunately, I can't remember. But I would presume that if they were there, they would give appropriate legal advice and direction.
And so the other matter is in relation to the Mr. Mitchell's recollection of superintendents that were present during the course of his tenure in S Squad. The fifth name, or the fourth name actually, that was he recalled was McKinney, Julian McKinney, who we are familiar with. Moving then back to the Austin against the Met litigation, there was obviously some liaison between the Met legal team and Special Branch. Firstly, you're involved as a witness, but also as a researcher, if you like, into the background of those involved in the litigation, not only Lois Austin herself, but also the witnesses that are providing evidence about May Day 2001. Is that fair to say?
Yes, I think that would be fair to say.
Behind tab 12, we have MPS 0749876. This is an email from if we can, it's the email I want to have a look at is the second email down the page. We'll work in chronological order. So we have Lawyer 1 emailing to you in the middle of the page. You see this second email down. I asked the May Day Civil Actions team if there was anything known at Special Branch regarding the claimant's witnesses. The result is shown below. Obviously, I don't know quite how sensitive the information is, but if there's anything the legal team is allowed to know, it would be helpful. Can you please look into this for me and give me a call at your convenience? So that's from Lawyer 1 to you. Lawyer 1 being the solicitors for the Met. If that can be reduced down, please. And what we see below is on page 2. Gov, we've had a reply from such and such, redacted, regarding the Special Branch checks. So many individuals are known, 2 organisations are known. So in terms of the research then you did into those individuals and organisations, can you recall making those investigations?
I can't recall making the investigations, but as it's documented here, I have no doubt that they took place.
And in fact, you say at the top of page 1 in response, I will seek to find out what is known and get it in a form we can use. And then you make reference to an interesting article on Italian anarchists. It highlights a trial in Italy of a group who have the same views of May Day 2001, where they liberate property from shops and then redistribute it to the populace. The group were I think that's meant to say inspiration for the Wombles, etc. So So you're looking into the claimant and her witnesses in the context of what they knew from May Day 2001. What steps were you taking in order to do that?
What searches would I be undertaking?
Yeah, how would you go about looking into that?
I would delegate it to the officers on the desk who were responsible for looking into these organisations. And I would say what the brief was and who it was for legal services. It was a request for them, and to be minded with what they can give them.
Okay, and would that be, when you say on the desk, you mean C Squad?
Yeah, C Squad.
Was that fairly standard? Had you received requests like that before, or is this something very unusual?
I can't remember if I'd received requests like that, but from what I recall, legal services at the time had staff who were cleared to SC and DV level, so they were allowed access to sensitive material, and there was a lot of, I would say, they were used quite frequently by Special Branch.
The Italian connection that you make reference to at the top, any thinking around Carlo Soracchi being the person that you needed to speak to then?
No, not particularly, because I think the group were known, and please forgive my attempt at Italian, I think it was known as Tutti Bianco, which I think meant white overalls movement. And we had very good UK police liaison with Italians, and also, as I think it said there, it's an interesting article from a newspaper, sometimes where you get some good intelligence.
Did you make any direct contact with DCI Dell, who was heading up the SDS at that time?
No, I wouldn't have made direct contact on him on that.
Did you request any written briefings to be made by the SDS for the purposes of the litigation?
No.
We understand that there were some written briefings that DCI Dell says that he would have written to council.
Yes, again, these would have been requests from legal services through probably either me or C Squad to DCI Dell. There weren't requests for me for my interest. They would be requests emanating from legal services.
And when such briefings are sent back to council in the legal services, would they have come back through you?
Not necessarily, no.
Do you recall seeing any written briefings?
I can't recall at the time receiving any. I have saw one in a package which I didn't recognise, but I can't remember receiving any at the time. It would be unusual for me to see information at that level. It would normally go to the desk to be collated and then sent on.
Do you recall hearing anything about Lewis Austin being represented as a wild radical?
No.
Behind tab B13, MPS 07498882. This is a typed gist of a telephone call on the 1st of December 2004. We can see telephone call Alan Mitchell. Austin has a file, mainly when she was with a militant youth group, which would have been Youth Against Racism in Europe. Can look at it. Others get mentions here and there. Do you recall having a telephone call at the beginning of December? If we reduce that down, please.
No, I don't, and I can't see who it's from, perhaps for reasons that I should guess at. But no, I can't remember that.
The understanding is that that's coming from the legal team. Do you recall letting somebody from the legal team see the material that you had on Lewis Austin in Special Branch?
I can't recall having let anybody from the legal team see that. That's not to say it didn't happen, but I can't recall it.
We can see at the bottom, sorry, it's still quite small, but the appointment to attend SB 4 p.m, 14th of December. Do you recall having somebody from the legal team come over on the 14th of December?
I don't recall it, but again, that may well have happened.
Yeah, this might help. Behind tab B14, MPS 0749811. We can see this is an attendance note from the 14th of December 2004. And lawyer 1, which is who we think was writing that attendance, that telephone note, attending Detective Chief Superintendent Alan Mitchell, and Inspector redacted at SB, to look at this pink secret docket on Lewis Amelia Austin. So do you recall having the legal team, or at least the solicitor, coming to inspect the file now, and in particular looking in relation to what was known about Lewis Austin?
No, I don't recall that. But again, it looks as if it happened, but I don't recall it.
That can be reduced at paragraph 4. We can see that there's the rise of right-wing extremism, that paragraph. It suggested that Lewis Austin will ooze charm in her favoured role as police liaison to find out how much police know about YRE. So at the time she was a national organiser for YRE. That, we know, is a quote that comes from an SDS report. Were you aware that SDS reports were being put on her pink secret file in Special Branch?
No.
Would you have had access to those SDS reports?
If I'd wanted to, then yes, I would. But again, given the portfolio of work I was undertaking, it wouldn't be routine for me to ask to see SDS reporting on any particular individual.
And in terms of your previous role on C Squad in the public order area, you were familiar with Lewis Austin?
No, I would say that I wasn't familiar with Lewis Austin. There was a whole range of individuals who would have been of interest to C Squad, and I wouldn't like to single out one particular individual as a special case. So I can't say that she was somebody of special interest to me.
Would she have been somebody that was regularly reported on?
Again, I wouldn't like to comment without having access to the file to see how many entries there was on the file.
We can see some excerpts from the file that's set out below in this document, and we can see a bit of a history of the types of campaigns that she's been involved in and the organisation she's been involved in. There's no sense that Lois Austin was anything other than a genuine campaigner against racism and social rights. She's standing up against the far right and exercising her own rights within a democratic society. Is that fair to say?
That could be one opinion. But I noticed that also they were a member of Militant Tendency, and Militant Tendency was an organisation that I think at the time was of interest across various agencies, which is probably why the file was opened in the original situation.
And is that just a left-wing political party?
Without wanting to go into sort of history of the Militant Tendency, it was regarded as a Trotskyist infiltration group within the Labour Party, which the Labour Party took some years to disestablish it from within the party.
And ultimately became the Socialist Party.
Yeah. And again, I wouldn't like to necessarily be quoted on it. It may have, at one time when the word subversive was more commonly used, have been classed as a subversive organisation, that being the militant tendency at that time. And Labour politicians of that era spoke out quite vehemently against it.
No convictions, no suggestion of violence within this summary. Presumably, if she had been convicted of anything, that would have been something that would have been flagged.
I would presume if she had been convicted of anything within the Metropolitan Police District, yes, it would have done.
In effect, was Lewis Austin simply a thorn in the side of the government at this time through her campaigning?
I think to say that they were a thorn in the side of the government might be taking things too far. And I think the government of the time would probably think that this wasn't an individual who was a major contributor to sleepless nights.
The penultimate paragraph on page 2 says that it's thought by Special Branch that this civil action may have been taken partly to flush out what the MPS knows about her and Special Branch methodology generally. Is this just a very suspicious take on Lewis Austin bringing a genuine civil action for breach of her fundamental rights?
No. At the time, there was other organisations which Special Branch were looking at, which, together with partner organisations, believed that other organisations were actually using criminal and civil proceedings as a means of establishing police and security agencies' methodology. And it may well have been that at that time that this was another throwaway remark to suggest that that line of behaviour might have been taking place by this group.
Behind tab B15, MPS 0749804. This is an attendance note, again by L1, on the 5th of January 2005. So this is the lawyer speaking to somebody from Special Branch. And we can see at paragraph 3 that somebody described the Socialist Party itself as an insidious and devious organisation. Sorry, it's the paragraph just above. Militant by name and nature, it works behind the scenes, gradually bending people to its thinking and is the enemy within. Its objective is to overthrow governments and create world socialism. We heard evidence from Lois Austin last year and also in February of this year, and her campaigns have been around education and work, housing, and the sorts of socialist principled campaigns that one might expect. In terms of the way that the Socialist Party is described here in a lawyer's note of a meeting, was there really a very, very skewed perception of what Lois Austin and her claim was all about?
I don't think so, no.
Did that fit with what you thought the Socialist Party was like at that time in 2005?
I cannot now in 2026 give an opinion of what my views on the Socialist Party at that time would have been. It may well have been a different beast from the beast that it may well be now. And again, I would have to look back into quite a lot of information to give you what my view in 2005 might have been.
Page 2, paragraph 1 of this document links Lois Austin's partner Neil Mulholland to issues relating to Northern Ireland and the Troubles. Again, is this trying to smear the claimant and her and her claim?
No, I don't think so. I believe it's just trying to give some background on the claimant and the claimant's worldview. Page
2, paragraph 3 We saw there the claimant's witnesses are described as hardened activists. And then we also go on to look at Louise Christian, the claimant's solicitor, and the suggestion that she's a member of the Socialist Alliance. Reference to Sadiq Khan, when he was a partner in the law firm Christian Khan, obviously now Mayor of London, but looking at them in a very suspicious light, as if their actions in representing Lewis Austin are somehow malicious, potentially. Is that what you were investigating? Is that what you were looking for some reason to undermine the litigation itself?
No, not in the slightest. My take on that is slightly different from yours, in that I look at it as it's just giving some background on the individual. And because, as you have said, these people are regarded as respectable individuals, it actually rebalances the picture of the claimant from being a wild militant if her individuals are people of upstanding character.
There are some articles attached to this letter, I think, in relation to Louise Christian on that document. Do you remember trying to find open source material in relation to Louise Christian and her activities as a solicitor?
No, it's not something that I would have been interested in doing.
Lewis Austin had given evidence about what happened on May Day 2001 when she was kettled in Oxford Circus along with about 3,000 others. No toilets accessible or water. We understand she was lactating as a young mother and needed to get back to pick up the infant from the childminders. What value did reporting like this provide to the defence? What was the purpose behind this background research?
I think you would again have to ask the Directorate of Legal Services what benefit they gained from it, as they were the people doing the original requesting. We were just in effect facilitating what to Special Branch would appear to be a reasonable request from lawyers representing the Commissioner.
Behind tab B16, please. MPS 0749862. Page 2 first. We can see this is an email from John Beggs, the counsel to the Met Police, to Lawyer 1 on the 10th of January 2005 at 9:05 in the evening, regarding the potential Socialist Party links between the claimant's witnesses. I'll give you a moment just to read that. Do you recall that being a real concern at the time when you had met with the lawyers for the Met about there being this potential for a conspiracy or perverting the course of justice because people were saying that they weren't members of the Socialist Party when it was suspected that they were?
No, I don't remember that.
We can see down at the bottom, can Mr Mitchell consider devoting some more resources to this point, given the potential criminality of what Austin and her followers are attempting, if the person's intel is accurate? I mean, was this seen to be a real problem? This wasn't just a legitimate civil claim being brought by people that had been detained in Oxford Circus for hours. It was a potential criminal conspiracy to pervert the course of justice for some reason.
I think Mr Beggs obviously thought it was, but the fact that that wasn't pursued obviously meant, in my opinion, that the intelligence wasn't acted on, and that wasn't the case.
Did you have concerns that this isn't the job of Special Branch, or this isn't the job of my SDS unit? Did you push back on this at all?
Push back on what?
The request to dig around as to the background of whether somebody's a part of the Socialist Party or not.
I would have probably questioned what the rationale behind it was, and I would have been satisfied by whatever counsel, Mr. Beggs, and Metropolitan Police Legal Services had said at the time.
Looking at page 1 of this document, please. This is now an email from Lawyer 1 to you. So this is following up on that last email we were just looking at. And this is sent on the 11th of July 2005. The following morning at 9:56 in the morning. And dear Alan, recent information from from redacted urgent priority, please. This urgency about information regarding the claimant's witnesses. And again, we can see in paragraph 3 there, reference again to Louise Christian, their solicitor. Aside from the fact that it's not clear what the benefit would be to the claimant if most of her witnesses were members of the Socialist Party or not, it's clearly something that was pressing in the minds of the Met legal team, and you're being asked to urgently look this up. Did you have any concerns about looking up the backgrounds of a lawyer?
I can't remember, I've no doubt that it came to me, but I can't remember what my views or opinions on it would be at the time.
The second part of this email is in relation to links between individuals targeted by CO11 fit teams, the Socialist Party and Lewis Austin. And here we can see reference to CO11 telling the lawyer that a number of individuals were being specifically targeted by fit teams. And we know that some of these people are engaged with this inquiry and have been activists in their own right. And were obviously able to give evidence about what happened on May Day 2001. Were you aware about individuals being specifically targeted by fit teams?
No, I wasn't aware, but it would be normal for uniform fit teams to target individuals of interest to them and their public order duties during demonstrations and protests.
Were you aware of any individuals being harassed by fit team officers?
Certainly not.
Was that an objective at all of special branch or investigation teams in relation to activists, campaigners?
Fit teams were managed and controlled by the public order branch and were not deployed in any way through special branch management.
Deliberate targeting by fit teams could inhibit the desire to exercise their democratic rights to assemble and protest. Would you agree with that?
No, I would go back to the reason the fit team is there is to enhance the uniform public order intelligence to allow police to safely police public order demonstrations.
When HN236 gave his evidence to this inquiry on the 17th of March this year, 118 being Simon Welling's, page 91 to 94, he was asked about this fit team targeting and whether it had a chilling effect. He said, well, I meant that if you put extremely overt, close, police presence behind somebody, it's clearly going to disrupt their ability to do whatever they were hoping to do that day. And he went on to accept it could have a chilling effect. These people who were involved in the civil litigation with Lois Austin were not terrorists, were they?
No, they weren't.
And they weren't serious criminals, were they?
Not serious criminals, no.
So what is the policing value of finding out the information that you were being asked to find out for the purposes of the litigation?
I believe, and again, just on the documents I've seen today, one view might be put forward that it was actually to rule out the possibility that there had been perversion of the course of justice in some of the statements that had been made, and it was to clarify who, in fact, were the protesters, rather than to go with the assumption that there was a giant conspiracy to pervert the course of justice by the claimants.
We know that you were aware of HN104 Carlos Saraki under the name Craggy Island being in the field around 2003 at least. Did this request for you to look into who was part of the Socialist Party and these individuals trigger the request for Carlos Saraki to come and brief the legal team?
Not that I'm aware of. I wasn't aware that he had briefed the legal team. This is the first that I'm being made aware of that.
Did you make these requests known to anybody above you? Did Commander Williams become aware of this request?
I can't answer that question. I may have mentioned it to her. I might not have mentioned it to her. She would obviously have been aware of the litigation at the time.
Yeah. What about ACSO Vaness? Would you have had any dealings directly with him over this?
I would very much doubt it. Mr. Vaness was a very present figure and knew most of the things that were happening in the Metropolitan Police that affected his area of business. I didn't tell him that it was happening, but then legal services might have made him aware, the uniformed assistant commissioners might have made him aware, or it could have even come up at various meetings where the commissioner met with his chiefs of staff. I wouldn't like to speculate as to if or when he knew.
Would you have had any concerns about the authority for using undercover officers for this purpose?
Again, the authority, unless I was in the role of the acting officer for authorising, it wouldn't be something that would be within my grade or area of responsibility.
Is that where shit flows uphill? You would have raised it with your managers or not?
In terms of the authorities, I wouldn't be granting authority. And could you just clarify what it is you're asking me if I would have granted authority for?
Would you have gone to Commander Williams, because she was the one that was authorising UCA deployments under REPA, wasn't she?
Yes.
Ultimately.
Yes.
Obviously, Dell would make the request, and that would go up to either yourself or Commander Williams.
No, it would go.
You've signed
it
off
would
on a few.
bypass me and go to the commander, because although Mike Dell might make me aware of requests, most of the authorisations would go straight to the commander.
So you wouldn't have thought to raise this sort of request
Which
to her?
request is? Could you just specify exactly which?
The request to find out more information on the claimant and her witnesses and the people who are being targeted by FIT teams.
The FIT teams wouldn't be anything to do with Special Branch.
Sorry, the individuals targeted by them, those being the ones who are of interest to the legal team.
Again, I'm not clear from what I've seen that all the information that was provided was actually provided from an undercover officer. It could well have come from the desk officers from a collection of sources. I'm not quite sure, I'm sorry, I may be being particularly thick here, where the link is between the information and the undercover officer.
Okay, we'll get to a particular meeting in a moment, but behind tab B17, MPS 0749864. So this is an email from the 11th of January 2005. So this is the week before trial now. And if we start at the bottom half, we can see an email from Lawyer 1 to counsel, John Beggs, at 3:37 in the afternoon in relation to SP links between the claimant's witnesses. And he has discussed it with Alan Mitchell, who's happy for them to be challenged as to their membership. Alan Mitchell thinks this case is a conspiracy to get information out of the MPS. Lewis Christian has not been looked into and will not be unless something very significant is found warranting it. So firstly, was it your idea that this was a conspiracy to get information out of the MPS?
No, if I can go back to my previous answer when we're talking about it being something that was mentioned probably as a throwaway comment, and I think again it's been repeated here as a throwaway comment, given that it was strongly suspected that other organisations that we were looking at as a special branch were using it as a tool to find out police methodology and why they had got to wherever it was they were, if they were in the dock.
And what sort of information would warrant looking further into the background of their solicitor?
I think it would have to be exceptionally serious, which is why we've not looked into her as detailed there.
And would you seek any authorisation from your supervisors for the purposes of looking into the solicitor's background?
I think it would not even be something I would consider doing. As soon as you start looking at solicitors, you have to have, in my view, exceptionally strong rationale for doing it. And again, I would be looking to take legal advice as to what the current situation at that time was, if it was felt that there was enough information to launch an investigation. I mean, you're talking about an investigation there, and I would say it would have to be very significant. And also I would be wanting to know what the legal safeguards were around the individual and to ensure that officers weren't breaching that.
Looking at the top half, the response from Mr Beggs to Lawyer 1 on the 11th of January 2005 at 4:45 in the afternoon. We can see that he suggests, let's put the question first and see if the replies, if blank, deny even support for the Socialist Party, then we can discuss with Mitchell whether this amounts to a sound basis for raiding SP's offices to prove a crime of perjury or pervert, etc. So, had you had any discussions prior to this email about the options for raiding the Socialist Party offices in terms of membership lists?
I've no recollection of that at all, and it looks to be a rather draconian step.
Would you have serious concerns about that?
Absolutely.
Did you have any discussion about less intrusive steps of finding out whether they were members of the Socialist Party or not?
Not that I can recall, no.
We can see in paragraph 3 that there's reference to getting the message of violence to the judge. Given that you were on C desk at the time when May Day 2001 happened, and you're a witness in this litigation to the threat assessment, you're speaking to that, aren't you? That's why you're brought in as a witness. This core message of violence, were you able to give any more detail in relation to that, in relation to Lewis Austin in particular?
I can't recall at this precise time what my response to that would have been and what my action would have been.
Were you ever asked to enhance your evidence about the threat assessment as to the threat of violence of May Day 2001.
No, to do that would be a very dangerous direction of travel, particularly if it was asking me to alter threat assessment, which was already common knowledge within quite a wide area. And also, it would be potentially illegal.
You knew at the time from the pink file that Lois was not violent. Do you accept that?
I accept that on the file it said they weren't violent.
And there was no reporting to suggest that she was violent.
On the information I've seen today, that is the case.
Was counsel looking for some intelligence that Lois Austin or her witnesses were violent?
I think that, again, is a question for counsel. It's not one that I would feel qualified to answer.
Were you able to say to the legal team that you've got information to show that the Socialist Party, Lois Austin, were not violent? So to undermine the reference there to violence in her claim?
I can't recall what I would have said at that time.
We understand that the skeleton argument that was put before the judge said that the police had no knowledge of where the threat of violence emanated from. Were you able to say that you at least knew where it didn't emanate from, and it didn't emanate from Lois Austin and her group in the kettle at that time in Mayday, Oxford Circus?
Again, I can't say that because, again, I don't have access to that information at the moment, and I don't have access to the information of what the thoughts and the actions of her and her associates were whilst they were in the so-called kettle.
Carlo Saracchi had that information. Was there a way that Carlo Saracchi could have disclosed that to the council?
I honestly don't know that. It's not information that I've been made aware of. If he put a report in and the report was actioned, it would have eventually been put in with the rest of the information from the C-Sport officers. But again, it's a hypothesis that I'm not able to really take forward.
We have Carlo Saracchi's witness statement, which is UCPI 35550, page 114, paragraph 259. Carlo was there near to Lois on May Day 2001 in the kettle, and he says he was assisting with stewarding and amongst a large group of Socialist Party activists, probably more than 20 who were kettled. Page 114, please, paragraph 259. And if we can have the next page up as well, if we can have them side by side. And he remembers that Lois Austin was in the group, and I think if that's reduced down, we can see both. I'm just going to summarise effectively what he says. And he recalls that he does not remember any specific incidents of violence occurring. And he recalls being asked by counsel about her activist activity and her character, which he provided. She was an activist in the Socialist Party, the Walthamstow branch. She was involved as a spotter on occasions. She was an outgoing, feisty person, not a violent person. He says she may have been present at May Day 2001, and obviously we know that she was. Would you have expected him to provide information like that to counsel when we know they met? They met later on the 17th of January.
Again, I would be speculating as to what information he gave to counsel. I can't remember him meeting counsel, and this is probably about the first occasion that I've seen information that he met with counsel. I hadn't realised he'd met with counsel.
Do you accept that that is information that would undermine council's approach to the litigation, which was to suggest that it was very violent, and that message of violence that needed to be got over to the judge is undermined by what Carlo Soracchi himself says about what was going on in the kettle.
I don't feel it's my place to say whether it would have undermined council's argument. Again, I think that a question perhaps better asked to council. I don't feel qualified to answer what the council's strategy was in that matter, and would not necessarily want to go down that line.
If we can go over onto page 116, I think that sets out. Okay. That's all I want to ask about that. If we can go to tab B18, MPS 0749865. This is an email from you, Mr. Mitchell, to Lawyer 1 of the 11th of January 2005, 5:19 in the afternoon. So here you say, I've spoken to blank and asked for the info he gave you in writing to enable me to answer questions on the linkage between witnesses in court if this is required. I'll phone you tomorrow on the 12th of January to discuss this issue. Moving on to tab B19, we have the telephone call note of the 12th of January 2005 between you and Lawyer 1. Zero 749-809. So here we can see that you're saying that you're working on it to see if any open source corroboration. We'll get something in writing this afternoon or first thing tomorrow. Happy to front it for SB at court. Would speak to judge on his own and cannot compromise the source. Were you happy to speak to the judge about the background information that you had been able to gather from SB intelligence?
Yes.
And moving on to B20, MPS 0749810. This is an attendance note that indicates that we're looking for a link between Lois Austin and her solicitor. Did you have any sense of how important that was?
Sorry, could you repeat the question?
There's seeking a link between Lois Austin and the solicitor Louise Christian. Why would that was something that was seen to be important, was it? I'm asking you similar things again. I appreciate that.
Again, it's a Directorate of Legal Services report, so it was obviously important to the Directorate of Legal Services. I can't answer that question, I'm afraid.
Moving to the actual meeting that Council had with Carlo Soracchi. We understand from John Beggs's witness statement, which is UCPI 5039326, page 2, this is his first witness statement, and at page 2, paragraph 5, he says, I met with him because I had been given some briefings in writing about what he could say about Lois Austin. So we know that the meeting did happen between John Beggs, now Casey, and Carlo Saraki. Page 3, paragraph 10, he says, I think the meeting came about because some of the written briefings from the UCO did not directly, but via his supervisors, seem to portray Lois Austin as some kind of wild, radical, possibly involved in very serious matters. I was asked whether I wanted to meet with the UCO, and I said yes, because as stated, I was sceptical about the written briefings. So these written briefings, are they the written briefings that we saw referred to earlier, that you were looking to get is something in writing
I can't
to the lawyer?
I can't say specifically that these would be the briefings that he was referring to.
We understand that DCI Dell had written these briefings. Mr. Beggs suggests that at paragraph 12 at the bottom of this page, that the written briefings were hyperbolic and paranoid, like Reds under the bed. It may be over the page. Was that still the sense of Special Branch, even in 2005, that the Socialist Party members were Reds under the bed? You know, that it was people were very suspicious of them, committed socialists. This is something that needed looking into, investigating.
No, not particularly. I can't comment on Mike Dell's views or opinions on it, but certainly it wasn't the view of Special Branch. A lot of our effort and direction was looking at an area that I'm not allowed to discuss here, and that I would say would be where quite a lot of our direction was going at that time in relation to violent disorder, etc. In relation to this organisation, it would be in terms of public order and assisting Uniform Branch to effectively police the streets of London.
Tab B21, please. MPS 0749812. We can see here this is an attendance note of the 14th of January 2005, so just 3 days before the trial commences. Telephone call between John Beggs and the DLS, lawyer 1. He will ring Mitchell direct on his mobile. So were you having contact with John Beggs in the days in the run-up to the trial starting?
I can't remember whether I spoke to him on the run-up to the trial or not. As I was given evidence, I may have spoke to him, but whether that was about my evidence or anything else, I couldn't say. I can't remember any conversations on the run-up to my appearance.
As well as being a witness in the trial, were you also involved in the strategy around how to present evidence in trial?
No, not at all. That would have been an issue I would have thought rested better with legal services and with counsel.
Were you involved around the decisions involving disclosure?
Again, only if there was particular sensitive source issues which could compromise the safety of an individual. That would be the only time I would look to get involved, or if it was information from another organisation.
Is it fair to say that you were involved in evidence gathering in relation to the claimant and her witnesses?
No, I don't believe it is fair to say it was evidence. We were responding as requests for information from our legal services team.
You say in your witness statement 2, at paragraph 20, that you were basically limited to being a witness at trial, and you state you were not aware of the tactics, decisions or knowledge of information in the hands of the legal team. But in fact, is that not quite accurate, because you were involved a lot more in the run-up to the trial in terms of conferences and discussions with the council legal team.
Sorry, I think it was highly accurate at the time when I made my statement. When I made my statement, I hadn't been presented with any of these documents, didn't know of their existence, and was trying to remember an incident that happened 23 years ago. I would still say that my involvement was to support the Commissioner and the Metropolitan Police legal team in defending the action. I don't think it would be fair to say that I was an active participant in how the case was conducted.
I think just in terms of whether you had the documents before, when you made the statements, your second and third statements for the purposes of this hearing, you did have the documents that I've been referring to since lunchtime. I admit you didn't have the ones referred to just before lunch, but you did have these records to be able to show that you had involvement with the legal team in the preparation for the trial.
If that is the case, I can't dispute it, but as recently as Friday, I was being shown documents which, again, weren't included in my statement. So I'm uncertain as to when I saw certain documents and didn't see some others.
Okay. You weren't shown this next document I'm about to take you to, which is MPS 0749817. It's an attendance note of the 17th of January 2005. And this is in relation to 17th of January is the first day of the trial. This is in the evening of that day, 5:50 p.m. And it's a telephone call between Lawyer 1 and Counsel John Beggs. And we know that he was, well, the note is, he was told to attend a certain location between 4:30 6:30 to meet SB informant. Told AM that he'd be there at 5:30. He has been waiting since 5:15, now 5:50, no one has showed up. Gave him AM's Moby number. So AM, we understand, was you. Do you recall having a conversation with John Beggs about a meet on that first evening of the trial?
No, I have no recollection of that.
Do you accept that AM is Alan Mitchell?
Well, because I don't know the content of the telephone conversation, I don't really feel in a position to say that is definitely me. If John Begg says it's me, then it is me. It may well be me, but I can't for definite say it's me because I can't remember the call.
This might help. It's Lawyer 1's witness statement, MPS 0749960, page 9, paragraph 25. So this is the solicitor who wrote this note. And at paragraph 25, she said that on that date, she gave the mobile number of another person, AM, i.e. Alan Mitchell. So does that help?
Yes, it does.
Or they have no recollection
it does.
of it.
Yeah,
I think it's
it
clear that it was you. We understood it to be the case. And does that help you recall now whether you helped to set up that meeting that John Beggs had with Carlo Saracchi, that SB informant we know is Carlo Saracchi?
No, I'm afraid it doesn't help me with that at all.
Why would you be having contact with John Beggs in that capacity on that night had you not been the person to set up that meeting?
Because he would regard me as his point of contact, who might be able to get things done at short notice and to find out what was happening. I don't know that he had any details for any other people within the special branch, but he did know me.
And you would have called Dell?
Yeah, yes, I would have called Dell.
So you understood Dell was bringing the SB informant to the
No,
meeting?
I didn't understand that. I would have understood that from Mr. Begg's telephone conversation.
Okay. So you understood it from the conversation you had with Mr. Beggs?
No, what I'm saying is I can't remember the telephone call coming in, but if I had then realised that Mr. Beggs wanted to speak to Saracchi and DCI Dell, it would be because of that telephone conversation.
Were you, in fact, at that meeting?
I have no recollection of being at that meeting, no.
Do you recall being briefed by Carlo Saracchi at all?
No. I have no recollection of being briefed by him. I would have expected that if he was meeting with Mr. Beggs, there would have been another officer present, as that tended to be the way they would have held meetings. I can only remember having meetings with SDS field officers at safe houses, and again, that was on specific occasions with either, I think, the cover officer or management from the SDS unit present, and none of that was to discuss anything in this area of work.
Another document, again, was not in your pack, MPS 0749866. There's an email from John Beggs to Lawyer 1 on the 17th of January 2005, now at 10:30 in the evening. Good meeting, some useful general info about nature of beast, but nothing specific on anyone but Lois, Niall, and just about privacy. So what appears to have been some kind of secret meeting between Defence Counsel and an operational undercover officer, Carlo Saracchi, and his managers on the night of the first day of trial appears to have taken place. Do you agree?
From this note, it would appear that that was the case, yeah.
That was the night before Lois Austin was to commence her evidence over 2 days at the High Court trial. Do you recall the temporal link between the two?
No, I have no recollection at all of the trial.
Do you know why the meeting was arranged for then?
No, and again, it would be something that either Mike Dell or John Beggs or Carlos Garacci might be able to answer.
Do you agree that it must have been quite an important meeting for counsel to take time out of the first day of trial in the evening before questioning the key witness in the case to come to a meeting? It must have been an important meeting with an anticipation of getting some fairly important information from that undercover officer.
Again, I wouldn't want to assume anything, but I think if Mr. Beggs wanted to meet the officer in question on that evening, then it may well have been important for Mr. Beggs.
What would have been so important that couldn't have been put in an email?
I have no idea.
It appears to have been accepted by DCI Dell that he was probably at the meeting, albeit he can't remember the details of the meeting. We know John Beggs was at the meeting, and we know Carlo Saracchi was at the meeting. From John Beggs's witness statement, his first witness statement, paragraph 8 on page 3, I don't need to bring it up, but he says, there were, I think, 2 other officers at the meeting of higher rank, perhaps a DI and a DCI. Can you help us with who would have been in attendance, the DI and DCI?
I can only presume that if it was Carlos Garacci, one of them would have been Mike Dell, and the other may well have been his deputy, whoever was the DI at that time. But again, that's an assumption on my part.
HN53, who was his DI at the time, said in his witness statement for MPS 0750008, dated 13th February 2026, at page 3, paragraph 8. He says, I have no recollection of asking Carlo Soraki to speak with counsel to the MPS in relation to the May Day 2001 proceedings. If this request had come to me, I would have consulted Mike Dell and Steve Beals initially, and then produced a memo setting out the advantages and disadvantages from the SDS perspective, so that approval could be sought from the SO12 senior management team. At the time, would that have been you?
It depends. Again, because it is dealing with the use and conduct of an SDS officer, it may be something that would have gone to commander rank, an ACPO rank. But again, I wouldn't want to necessarily speculate, but that would have been, I would have thought, the logical place for it to sit.
So that, sorry, who was that you said?
I would have think at that time it would probably be Janet, I would have thought.
Gone up to Janet Williams.
I would have thought
for
if
approval.
that was a request for use and conduct around an SDS officer meeting a counsel in a live court case, then that would have probably gone to her for authority.
And had she not been available, that would have fallen to you.
It would probably have fallen to me. At this period of time, I wouldn't have known what the protocol was if it was in connection with something like that. Something like that, it may well have gone to another ACPO, such as the Director of Intelligence.
But given that you...
But it might have come to me if the commander wasn't available and I was acting commander.
Yeah, and given your relationship with counsel, having met with counsel, your liaison with the legal team, that would have made sense, wouldn't
Actually,
it?
if I could correct it, I think at that time I was a superintendent, so it would have gone to the relevant chief superintendent.
I think you were chief superintendent
Well, in
this
that
time.
case, it would
This is
have gone to me.
2005.
Yeah, it would have gone to me in 2005.
Looking at the REAPER authorisations in Carlo Soraki's pack, MPS 0526804, page, so if we scroll down, you can see this is a whole composite of documents relating to the initial authorisations and reviews and renewals. But if we go to page 54, these are documents, the type of documents you will be familiar with. I'm not saying that you've read this recently, but these are the sorts of documents that you would have completed, wouldn't you, in reviewing SDS operations?
If I was as the acting ACPO rank, yes.
Okay. And at page 54, we can see this is a review for the use and conduct of a UCO in March. Page 56, in relation to Craggy Island being Carlo Soraki. Page 56, bullet point 5, says that UCO Craggy Island has been in a position to provide background briefing to both Metropolitan Police legal advisors and SO12 senior management in the current May Day 2001 civil case, where individual activists with support from the SP organisation are suing the police. So here it appears clear that he briefed both the legal advisors and SO12 senior management. So did he brief you?
I have no recollection of meeting with Carlos Garaci.
Would he have briefed you in any other way rather than face-to-face?
No, the only other way that I would have got information would have been if an intelligence report came up from SDS.
And the person that he might otherwise be referring to in terms of SO12 senior management would be who?
It would have been the commander at that time, or it could have been Superintendent Esquod.
And the Superintendent Esquod, I think, was either Rintoul or Fuller, I think, at that time.
I wouldn't like to say.
Okay. Doesn't it make sense that it would have been you, given your involvement here? You've taken the legal team to look at the pink special files in special branch. You've had, I think, some involvement in researching the backgrounds. You're involved quite centrally in this, aren't you? Isn't it referring to you?
It doesn't say that it was me.
Is it most likely to have been
Well,
you?
I wouldn't like to assume that. It says SO12 senior management. It doesn't say specifically me. It may have been me, but that's not what it says.
We can see at page 39 this is an update, and this is now in May. It's signed further down in May. Again, an authority for the use and conduct of Craggy Island. And it's page 41 in relation to an intelligence case, bullet point 8. That it provided a personal background briefing to MPS Defence Counsel in the May Day 2001 civil action by members of the Socialist Party. Scrolling down, this request is signed by DI 53 on the 27th of May 2005, page 48. On page 49, we've got the customer squad comments from C-Desk DI. And the last sentence in that box says that the UCO Craggy Islands intelligence and assessment for MPS Council in relation to the recent May Day action was of significant value. For information to be of significant value, clearly this is not just Carlo Saracchi telling Mr. Beggs that she's a feisty, outgoing woman and a member of the Socialist Party and that sort of thing. What would you understand from this information being given in response to his intelligence by C-Squad desk?
Again, I wouldn't want to speculate. I believe that what the officer is saying is that it was a significant value because it may well have been that that was the feedback that he got from the legal team at Directorate of Legal Services. Again, without knowing exactly what was in the officer's mind at the time, it's difficult for me to say.
John Beggs's evidence in his witness statement was it was not of particularly useful value and didn't really tell him anything he didn't already know about Lois Austin. But can we take it from this note that in fact there must have been something that happened during the course of that meeting that was of more significant value?
No, not necessarily. I would say that here what they're trying to do is they're trying to show the effectiveness of the officer, and what they're doing is they're showing that yes, he's met MPS Council and that was a significant value. Again, it doesn't say that this was found by Council to be of significant value, and again, without speaking to the officer, it would be difficult to know what made him say that it was of significant value.
Behind tab B22, please, MPS 0043069. This is an intelligence report in relation to the Socialist Party's civil action against the police of the 19th of April 2005. So this is post the trial. The trial took place in January and February in the High Court. And this note, at paragraph 3, says that counsel for the police were able to discredit her and other plaintiffs. And paragraph 4 says that she's instructed her legal representatives to prepare an appeal as they believe there is still a slim chance of victory under the Human Rights Act, but nobody, however, is holding their breath. The suggestion here is that there's been some kind of ability to discredit, undermine the claim by the use of information given by Carlo Seracchi, and that he then is also reporting further about the outcome of that civil claim and the steps being taken to appeal. Do you have any concerns about this sort of reporting?
Only thing I would comment on is that it says that in there of the opinion that did not give a good performance while she was giving evidence, and as a result, counsel for the police were able to discredit her and other plaintiffs. That, to me, that sentence looks as if it's based on her performance in giving evidence rather than anything the police were necessarily able to do to discredit her.
We have some evidence to this inquiry that one thing that Carlo Seracchi was able to do was inform on what would wind her up in the witness box.
Well, again, I've not seen that. I've been shown the document and asked to comment on that document.
And one thing in particular being the Irish link with her partner. So given that that was information that was provided by you as well about that in the documents that we've looked at, has this all been utilised to undermine her in her evidence?
Not that I'm conscious of. Again, any information given by Carlo Seracchi to counsel would have to be something between Carlo Seracchi and counsel as to what was said and how counsel used that information. I can't really comment on it.
Does it appear here that it's not a level playing field in that the police have a spy on the other side of the litigation, in the claimant's side of these proceedings, reporting back everything that is known from inside their Lewis Austin's
No, I don't think that's
position?
a fair comment at all, because on the information I've seen, there is not any information that's been given about discussions between the claimant and their legal team or anything that would give Metropolitan Police information to assist their conduct of their defence of the action. But to me, it looks very much as if what has been reported is either historical information on the individuals or peripheral information post the event.
What's the policing value in relation to this sort of reporting?
The reporting in general about the party or just in general?
The reporting about the litigation.
Again, because of the information held on certain individuals with it, it may well have been felt by the defence that they wanted to ensure that from their perspective it was a level playing field and it wasn't a conspiracy, as outlined several times by John Beggs. And it would appear that Carlo Seracchi was able to confirm that there wasn't a giant conspiracy, and so the Metropolitan Police didn't go down that line.
Completely baseless suspicion about Lewis Austin and her claim?
No, I wouldn't agree that it's a completely baseless claim. I would say that on the information I have seen, the deployment of the officer and the information given was correct.
And a completely inappropriate use of undercover officer reporting?
No, I don't believe so, because the officer was reporting on a group and the information was historical. I haven't seen any information or much information from Carlo Seracchi on paper that supports the fact that he was reporting lots of information on the proceedings.
Behind tab B23, MPS 00...
Give me a moment. You were asked about the policing value
Yes.
of knowing that some full-timers are of the opinion that Austin didn't give a good performance while giving evidence, and that they regard the prospects of an appeal as having a slim chance of victory. What on earth has that got to do which is of policing value?
I would say that specifically has nothing to do with the policing value. I think that that is something that the officer has probably put in as a result, almost as a piece of information. It's not what I would class as intelligence.
Thank you. Forgive me for interrupting.
Thank you. Behind tab B23, MPS 0071194. This is an SDS manager's summary of HN104's deployment, the 13th, dated ultimately the 13th of the 11th, 2006. But if we go to page 8, please. Paragraph 1, we can see that during the course of 2005, Carlo Saracchi provided background information to Police Council defending MPS in a large civil claim by Socialist Party activists following their detention in May Day 2001, Section 60 containment at Oxford Circus. The main plaintiff of the claim was Lois Austin from the Socialist Party. MPS successfully defended itself against the claim, to my knowledge, never done before by SDS field officer. The suggestion here by Carlo Saracchi's manager is that Carlo Saracchi's involvement in this led in part to the successful defence of the claim. What do you say about that?
It could be read that way, yes. But again, not knowing what information Carlo provided to John Beggs, I wouldn't like to comment on whether the statement is accurate or not.
Given that this was such an important claim against the police, was that discussed at all within Special Branch?
What specifically?
The success of it and the involvement, you know, the contribution that Carlo Saracchi made.
No, I can't remember any discussion about it within Special Branch. It was something that had happened, and we moved on to other issues.
You were a witness in that claim, though, in that trial, and had been involved in the run-up to that trial. What discussions did you have then with the legal team about that and Carlo Saracchi's involvement in it, if anything?
I can't remember having any discussions post the event with the legal team.
We know from the witness statements of John Beggs and George Thomas that Lois Austin's performance at trial would have made no difference anyway, because ultimately it did not form part of the judge's decision making on the legality of the cordon and the police action that day. In terms of the threat assessment that was created and the presentation of Lois Austin and the circumstances that day portrayed to the judge, do you think that that's a fair assessment, or could Carlo Saracchi have provided information that would have put a different slant on his view of the events that day?
Not having the threat assessment in front of me and not knowing what the judge's thinking was, I wouldn't like to comment on that. I think there is a danger that Carlo Saracchi's involvement in is potentially being overrated.
Was any consideration given to disclosing the involvement of a UCO in the gathering of background intelligence on the claimant and her witnesses?
Again, I can't remember any discussion, and I think, as I've already answered, a lot of the information, the background information, was also obtained from within Special Branch existing records.
The involvement of Carlo Saracchi on the evening of the first day of trial would not have been part of the PII disclosure that would normally take place in the course of the trial, would it?
I can't honestly say. I don't have that level of knowledge.
We have one document that you won't have been shown before. It's MPS 0749868. I'm not too sure if we can bring this up, actually. No, it's not on Epic. Do you recall that on the day that you gave your evidence, on the 24th of January 2005, that Keir Starmer, who was representing Lois Austin as counsel, wrote to the MPS counsel suggesting that in light of Mitchell's evidence so far, I think we'd better ensure that the special branch threat assessments and any other advice passed by special branch to Messenger or French are at court as soon as possible. Do you recall having some involvement in that?
I can't recall that.
Do you recall having a phone call with lawyer 1 on the evening of you giving evidence at trial?
No, I've no
About PII
I've no
disclosure.
recollection of that.
MPS 0749850. Again, I'm not sure if this is going to come up on Epic. Do you recall a situation where Keir Starmer did not pursue the PII application, or challenging any PII application, that had been warned off in relation to that, and that was a cause of some celebration is not quite the word, but do you recall any of that at the end of the trial?
No recollection of that.
Sir, note the time, it's 3:30 and it may be a time for an afternoon break.
Yes. How much further do we have to go before we deal with Rule 10 process?
About 3/4 of an hour.
Yes. So be it. Then we'll have a break now. 10 minutes or quarter of an hour? We'll have a long 10 minutes then. Yes, right.
Thank you. I just want to ask you about some of the operations that you authorised under REPA as acting up as commander. So 2 documents, if I can have them side by side. These relate to HN236 Simon Wellings's operations. Now, the reason to have these 2 side by side is because one is signed by you in August 2003 and one is signed in August 2004. Now, do you recall authorising operations under REPA? I think we've already established that you did do that if Janet
Yes,
Williams
yeah,
wasn't available.
Yeah, yes.
And the authority for conduct is the text that we're interested in. In the August 2003 document, we can see that it's fairly short text, and no reference is made to relationships. Whereas in August 2004, we can see that reference is made to relationships. But 4th line down, that conduct will include establishing relationships with members of globalised resistance who will not know that the source is a police officer. Anything more intrusive than the establishing of such relationships and living the life of the committed activist is not authorised. Just this reference to relationships, living the life of the committed activist, nothing further authorised. Is that, in fact, reference to sexual relationships and the fact that they should be prohibited?
I can't be specific on that at the time, but it would probably include, starting around living the life of, it would include such things as drug taking, sexual relationships, I would say, would be within the gambit of that, whether that was in the forefront of my mind or not. But I think it would be generally, in terms of the relationship, drugs, that sort of thing.
And whether this is your own text or whether this is now standardised text within the RIPA authorisation forms, is the change between 2003 and 2004 a result of what was known by the Officer A and Officer B statements, in that we know from what we looked at earlier today that both Officer A and Officer B talk about sexual relationships in the course of their deployments?
I can't answer that question because I don't have enough detailed knowledge on when it changed or why it changed. It may well have been that advice came from stated cases or from the police management on the wording and what was acceptable. The original wording looks quite sparse, and it may well be that over time that they were asked and directed to include more information and detail.
Okay.
But I can't say specifically what the rationale for the change was.
Just to be clear, HN236 is not known to have had a sexual relationship in his deployment, but he made reference to others having sexual relationships in his Officer B witness statement. I just wanted to make that clear. So you're not able to assist as to whether that triggered this change in the wording?
No, I'm unfortunately not.
Other RIPA authorisations that you were involved in signing off on, MPS 0526935. This is in relation to HN18 Rob Hastings's deployment. If we can go to page 1, we can see that it's Commonweal was his code name. Page 176, please. If that can be enlarged, we can see paragraph 1 in relation to authority relates to commercial interests. I'll let you read that paragraph. HN18, we know, infiltrated International Solidarity Movement London and Dicey, disarm Dicey. In terms of the anti-business trajectory, the anti-war campaigns, was there a sense that part of the reason for his operation was the commercial interests involved in the arms manufacturing industry and the need to avoid embarrassment to the government? Was that part of the thinking around deploying him into those areas?
I can't say at this time whether that would have been a fact. I would very much doubt that it would have been a fact. I do notice that it says that I do not grant authorization.
Yeah, I'm not too sure that that is accurate, because I consider the following authorization remains appropriate. So I think you're not granting the authorization from at the outset, but you're updating it. If we can scroll down to where you sign off on this, I think it's the next page. We can see you're signing on behalf of Commander Gormley.
Yep.
And we can see there, my authority for use and conduct commenced on the 22nd of November 2005, expires a year later, but this is an update midway between that time. So this is May 2006. Does that help?
Yes. Could you repeat your initial question, please?
It was about HN18 and the reason for his deployment, in terms of whether there was a motivation to protect against the threat to commercial interests, particularly in the arms field, or to avoid or avert embarrassment to the government.
My reading it would be to prevent criminality in relation to the business and the company. It would be how I would look at the rationale.
And how is it that the Palestinian cause in particular featured in HN18's deployment?
I can't remember at this stage what the rationale for that was.
We heard from DCI Dell that infiltration into ISM was meant to be a stepping stone, yet he remained within ISM for the duration of his deployment. Was that something that you were aware of?
No.
Okay, so that message from DCI Dell hadn't...
I can't remember that conversation from, again, 20 years ago.
Page 151 of this authorisation composite, paragraph 2. So this is a later authorisation. Paragraph 2 says that ISM was virtually moribund around this time. Do you recall having any thought as to whether HN18's deployment was still valid, if it ever was, under your watch?
I can't recall having thought about it at the time.
Oh, it's back on. Page 152 talks about collateral intrusion. We've heard evidence about those that came into contact with HN18 in the course of his deployment, including Atif Chowdhury and a woman we know as Maya. We can see here it says there have been no instances of collateral intrusion in this period. Focused tasking and briefings will continue in an effort to minimise any such intrusion. Some collateral intrusion is inevitable, particularly in areas that consistently attract eccentric but well-intentioned persons. and CW is tightly focused on those individuals planning antisocial and serious manifestations of public dissent and disorder. Knowing now what we know of HN18's deployment, where he spent considerable time infiltrating the private life and the family of Atif Chowdhury, and the home life, the personal life, and the sexual life of Maya, was this sufficient protection to try and mitigate against the risk of over-intrusion into people's personal lives? And by that I mean this form of RIPA authorisation. Was the oversight sufficient in order to try and protect the public against overly intrusive undercover operations?
I think plainly, no, it wasn't.
What more could have been done to protect against that sort of intrusion into the lives of members of the public?
I wouldn't want to give an off-the-cuff response. It's something that I would require some thought about.
These RIPA authorisations were meant to be a form of protection, weren't they, for members of the public, to avoid unnecessary, disproportionate and unlawful intrusions on their lives. Why was it not working?
Again, my perception would be that most of these forms were a means of showing that issues had been thought and had been considered. But again, I would say that historically across a lot of the RIPA authorisations, perhaps thought wasn't given into what is it we're trying to achieve here. Are we achieving it? Could it be done better? And is there a danger it just becomes a purely bureaucratic process?
Do you think that was the case, that it was an almost tick box exercise as opposed to an intrusive form of close management?
I think it would depend very much who was completing the information and the forms. I think some forms potentially became, I wouldn't say cut and paste, but formulistic words were used without actually what it was they were trying to achieve. Again, just looking at these now historically, there doesn't appear to be much detail as to what the control factors are to ensure that what is being written is being complied with.
Did you have training on human rights articles, in particular 8 and 10 and 11?
Again, I can't say specifically in relation to those articles. I believe I would have probably, like other officers in my rank, had some form of UCHR training, but I can't be definite or specific on that.
Who would have provided that human rights input into training?
It would, and again, I'm having to really think back here, it would either have been Met Police Training Board or perhaps more likely to have been organisations or individuals contracted by the MPS to deliver that training.
And would that have been training for people within Special Branch with these responsibilities of completing RIPA?
I think it would, again, I don't know it would be RIPA specific, and I don't know that it would be SB specific. I would believe it may well be for management in general. As to being specific for officers doing it, I can't remember specific courses. I can't remember doing a specific course on RIPA authorisations.
Is it likely that there wasn't training on RIPA authorisations?
There may well have been. I just can't remember whether I did it or not.
What about the national intelligence model and the minimum standards in relation to that? What were the implications of not meeting those minimum standards in the lawfulness of deployments that were being authorised?
At the moment, I can't remember. There was information about the National Intelligence Model. Training was given in the National Intelligence Model, and Special Branch moved to the National Intelligence Model at one time. And I know that one of the other units, the MPIU, had a review commissioned a review into its compliance on the National Intelligence Model. But what the result of that was and what the specifics, I'm afraid I can't answer at the moment.
If we can move to page 193 of this document, please. So again, within HN18's composite of RIPA authorisations, we can see here that this is a quality assurance review completed by DCI Flood on the 21st of March 2006. Is that something that you were familiar with? Did you know that those quality assurance reviews were being conducted? This may be after your time.
I think it was after my time. I can remember, I believe it was Janet that commissioned Frankie to do that inspection. So I may have been aware that he was doing a review, but the actual contents and findings of it, I can't remember.
And the last box, points 1 and 4, said that this was from the beginning of February 2006, that there was an SO12 RIPA compliance unit started to take on the responsibility for quality assurance of all SDS files. Point 4, the authorising officer will conduct reviews as in line with best practice guidelines disseminated by the CSO, with the addition of a new review page. During the course of your tenure, did you not have the benefit of best practice guidelines?
I can't remember. I can't remember having best practice guidelines. And again, thinking back, I wouldn't have known who would have issued the best practice guidelines at that time, given that the authorisation of undercover officers was quite a unique area of police authorisations.
When you are reviewing authorisations like this, you would have had a reasonable understanding of the deployment of an officer, is that right? Do you look back over previous reviews?
I would look over the reviews, but also what I would try and look to do would be to speak to line management officers to try and get behind what was in the writing.
So you would have a particular briefing by somebody?
Yes, I would have a particular briefing, and although I would imagine it's not in your documents, there is or was examples of me refusing deployments under officer safety reason.
Do you recall, in relation to HN18, him reporting on matters touching on the John Charles de Menezes campaign, the Justice for John campaign? If I can refer you please to MPS, page 152. Sorry, no, that's the page I've referred you to before. Actually, it's not in this document, I don't think. Do you recall him reporting on those involved in the campaign? I can bring up some of the initial intelligence reports. MPS 00655522. Is one example from 2006. Again, this may be post your time. John Charles de Menezes was shot just after the 7/7.
I have no recollection of that. I would think it would be unlikely to come anywhere near me, but I may be wrong, but I can't recall having seen that or seen any of that reporting.
Do you remember MPS interest in the campaign that started up following his death in 2005?
No, I can't remember any interest in that. My energies and direction was taken elsewhere at that time.
We know that there are a number of reports similar to this as individuals who are working in the campaign and their contacts are reported in an intel report like this. Do you have any comment to make on as to the appropriateness of that in terms of it touching upon that
again,
family justice campaign?
Without knowing the rationale for it and what was the authority and the rationale behind the authority, I don't really feel qualified to comment.
We know that DCI, Dell and potentially HN30 told HN18 not to report on matters concerning the campaign. Were you apprised of that? Did you have any knowledge of that?
I can't recall any knowledge of that.
Can I ask you about TBS, please? That's a cipher that we've given to the child fathered by Bob Lambert with Jackie whilst he was deployed as a UCO in the 1980s. We know that there was an investigation or the matter was raised by Op Hearn in 2011 or looked at by Op Hearn. The SDS had closed by that stage, closed down in 2008. But we understand that post-closure of the SDS, you held the rank of DCS within SO 15.
That's correct.
Is that where you, once the merger had happened and the SDS had closed down, you were within the counter-terrorism
That's correct.
Unit? NPCC 0005155, please. This is a 2011 email chain in which you are named and Peter Ward. Peter Ward says that you were his direct manager. We'll come to that in a moment. The 21st of October 2011, page 2, please. Start at the bottom. We can see here that Bob Lambert contacts Rob Evans, who is the author of the Undercover book and reporter in The Guardian. And at the very end, the penultimate paragraph, Bob Lambert admits that as part of my alter ego's cover story, I had a relationship with Belinda Harvey, to whom I owe an unreserved apology. That was one relationship that he had. Scrolling up, please. Oh, back to page 1. That is copied to you, so you were aware at the time that Bob Lambert had admitted to sexual deceit of Belinda Harvey. Is that right?
That would appear to be the case, yes.
Do you remember that?
I can remember some of the peripheral details and the concern being exercised by the Met Police at the time, but the actual chronology I can't remember in detail.
And were you surprised at that?
Yes.
MPS 0749744, please. This is his actual witness statement in relation to an investigation. This is dated the 7th of May 2025. Page 2, please. So he says, paragraph 3. At that time, he was working within SO15 as a member of police staff and believes that his immediate line manager was you and Commander Richard Walton. So is that who you were working with at the time, Commander Richard Walton?
I believe Richard would have been the commander, and I believe Peter, although he was working for us at the time, was actually attached to Special Operations Command as an operational security advisor, although working within SO15 at this time.
And so in terms of Peter Ward's involvement in, well, it says Operation Soissons, but what became Operation Hearn, you were directly above him. Was he reporting into you in terms of what he was looking into?
Yes.
As part of that
Yes, he would report.
investigation?
He would report into me, and he would also report into a gold group that I think had been established to look at issues arising.
And it says here that you had responsibility for the welfare of those officers who were still serving, who had worked in the SDS.
Yes, that makes reference to what I mentioned earlier, where I was asked to ask the officers if there was anything particular they had done that was likely to come to light, that it would be better for them to tell us now than us to find out, and also to look at the welfare. Around some of the officers, there was concerns that because they had been identified or ran the risk of being identified, depending on which area they'd been working in, security measures might have to be put in place to safeguard the individual officers and their families.
And did any of the officers that you asked disclose to you sexual relationships?
I can't remember anybody doing specifically, so no.
And did you speak to Mr. Ward about the contents of the Guardian email?
I probably did, yes.
And did you speak to him about contacting Bob Lambert to see if there were any other relationships that he had had, as well as the one disclosed?
I can't remember if that was part of our discussions or not.
We go to page 3, please. This is in relation to the consequence of Jackie, which is the mother of TBS, and somebody who had a deceitful sexual relationship with Bob Lambert. In terms of the investigation around that, how involved were you in terms of speaking to Bob Lambert and finding out exactly what was going on?
I noticed that I don't appear to be part of that gold group mentioned in para 7. When it comes to the investigation of Bob Lambert, I can't remember that I had a specific role in investigating him at the time.
We can see that in terms of the between 8 and 10, paragraphs 8 and 10, we can see that there were 2 gold group meetings, first on the 24th of October 2011, the second on the 8th of November 2011. And we can see there's reference to Lambert's contact with the Guardian newspaper and his relationships whilst undercover, and the fact that one relationship had resulted in the birth of a child who is known as TBS. There's also reference to the potential for him to have an hereditary disease. Do you remember discussion about that?
As I say, I don't think I'm shown as being at that gold group meeting. I was aware that Bob carried a hereditary gene because I'd attended, as a very junior officer, the funeral of his daughter. So I knew that he carried a hereditary gene.
But was this not raised with you by Peter Ward, who you were his direct line manager? Was there discussion
I don't think
about
Peter
that?
would have raised the gene. I don't know that he necessarily knew about the gene.
He must have known about it because he was in the gold group meetings, wasn't he?
Again, I'm not sure that his name is shown as being
Can we just go
listed
back
there.
to paragraph 7, please?
I mean, this looks to be a particularly high-powered group, and I can't see his name there. There may well have been other meetings held at SO15, SO level, which he and I attended, but this one, neither of us are shown as being present.
Given that he was involved Sorry. Pardon? Yes, thank you. We can see just past the black redacted box there, it says "and me," which will be Peter Ward.
Ah, great.
Thank you to my learner friend for pointing that out. I thought he was part of the goal group. So, yes, given that he was part of the goal group, was he not discussing these serious matters?
Yeah, he would
with
know
you?
that. If he was part of the goal group, yes, he would. Again, I would be aware of things that he was talking about, but I'm surprised I wasn't at the goal group. I may well have been absent at that time for whatever reason.
And we can see down at the bottom on the 8th of November, so we can take that down, please. Sorry. Reduce the expanded bit, but keep the document up, please. So we can see on the 8th of November, discussion followed about Lambert's hereditary medical condition and doctor privacy has been approached to trace the child. There is no wider responsibility for the MPS in respect of this. And paragraph 10, an examination of the minutes of similar meetings held in late 2011, early 2012 contain no record of there being any further discussions in relation to TBS. So was it your understanding at the time that a doctor had been approached, whether that's a medical doctor or an academic doctor, or somebody had been approached to trace TBS, no wider responsibility, and then it appears to go quiet in relation to TBS?
The only thing I can recall around TBS was hearing, and I can't remember who I heard it from, that when tests had been done on the child was not carrying the hereditary gene, which would potentially have been fatal to them. But that's the only thing that stands out in my mind.
We understand that Bob Lambert had contact with Jackie, but in terms of the MPS's responsibility towards TBS, what involvement did you have at all in terms of the moral, ethical, legal responsibilities of the MPS towards the child of Bob Lambert that was essentially a result of his deployment in the SDS?
Looking at that, it looks that that's a very cold legal definition of the MPS's responsibility. I can't imagine that any police officer would have, or member of police staff would have said that off the top of their head as a policy decision without consulting to find out what perhaps the cold, hard facts were in relation to the MPS liability. I would have thought that the MPS has both a moral and a financial responsibility to the child.
NPCC 00051 please. This is an email from Peter Ward copying you in on the 24th of October 2011, 9:55. And it's from Peter Ward to Bob Lambert, and he says that things are far more complicated than your email below sets out. I still stick to my original advice that you do not comment to the media or Peter Francis, even though you clearly have done so already. I hope the family issues are being resolved. The sense that Bob Lambert should not be making contact with others about this, was there a sense at the time that this should be contained within Special Branch, and it was a case of trying to maintain the neither confirm nor deny policy at that stage?
Absolutely not. No, I don't think it was a sort of issue that there would be any thought of containing it. I think it was that Bob was starting to take actions which potentially would harm him and perhaps his extended family. And it was a question of bringing Bob, I suppose, back into the fold of trying to resolve the situation rather than him trying to resolve it on his own at that time.
And page 2 of this document, where Bob has written to Rob Evans of The Guardian again, we can see down at about a third of the way down, yesterday I revealed to my family the secret of my relationship with Jenny. So this is another woman that he had a relationship with. What steps did you take in light of the fact that he'd had a number of relationships, fathered a child, to find out if this practice, well, I say this practice, but such issues were more widespread, given that you also knew what had happened, or I'm suggesting you knew what had happened with the A&B litigation in 2004. Were bells ringing in your mind at this stage at all that this is not the only person that's involved in all of this?
Again, looking at it, and I'm not sure what the chronology is, and when Kennedy came on the scene, whether that was before or after, but these would be issues that would certainly have raised alarm bells. I can't, at this stage, remember as to whether it was more widespread, but I think the very fact that Peter and I were asked to speak to those ex-SD officers we could to find out in a straw poll whether there was issues we needed to be aware of indicates that at least it was being thought of and discussed somewhere.
He says on page 3, line 6, during the last 10 years I've often wished I had employed the tactic of police partnerships with credible and legitimate non-violent animal rights campaign groups instead of the tactic of infiltration as a less damaging and more effective way of preventing political violence and intimidation by the ALF and related violent groups. What's your understanding of the tactic of police partnerships as a less intrusive form of evidence gathering?
Again, I would refer to the paragraph underneath in relation to his perceived success against al-Qaeda-inspired political violence in partnership with non-Muslim organisations. Bob was a very enthusiastic manager of a unit called the Muslim Contact Unit, who established very genuine links with the London Muslim community, in particular groups and individuals that had been in the past regarded as hard to reach. And I would say that he was effective in doing that and had the respect at the time of a great many people who we would have regarded as being hard to reach. And he probably is thinking that as a result of his success or perceived success within sections of the Muslim community in London, that might well have had a read across to the animal rights activists, and he could perhaps have, in effect, mirrored his success there.
Do you think that is something that could have been deployed in place of some of the operations that you oversaw?
Again, in relation to animal rights activity, it's difficult to say. When you look at the animal rights activity, certainly at its peak, it was actually causing more financial damage to the UK than the provisional IRA, and was a very violent, self-structured extremist group within the broader animal rights movement. Whether he could have engaged with these people who were involved in criminality in the same way he could have dealt with hard-to-reach groups in the Muslim community who weren't involved in criminality, I think is an interesting discussion for some people.
I'd like to ask you about an intelligence report, MPS 0527125, an intelligence requirement which looks at the intelligence requirements in respect of the SDS coverage for domestic extremism. And this is if we go to page 1, this is a document from the 21st of July 2006. We can see that you've looked at the document around 26th of July 2006. Page, next page, please, page 3. This is going to Detective Chief Superintendent Zinzan through you. And at the bottom of the page, we can see a handwritten note by you to Dave, that being DCS Zinzan. Can we discuss particularly 3.8 and 3.27? 3.27, when we go to that, please, page 19. Is in relation to Greenpeace direct action. What was your specific interest in that, or why did you want to discuss that in particular?
I can't remember now what I particularly would have wanted to speak to him about. It may have been the difference between, I think, Greenpeace London and Greenpeace in general, but I can't now, looking at it, think what I would have wanted to have spoken to him about.
Can we look at page 10, please? You can see here the second bullet point is about the visit of the Israeli Prime Minister Ariel Sharon to London in 2004. So during the time that you were had some oversight of the SDS. If you recall, this is about a suspected hoax stunt involving somebody wearing a suicide bomber's vest and jumping over a barrier to confront Ariel Sharon. Do you recall that?
No, I'm afraid I don't.
We've heard from the person known as MT, who is alleged to have been involved in planning this stunt, who says he had absolutely nothing to do with it at all, and it was in relation to somebody else suggesting something in a much more jokey kind of way, and it never came to anything at all. The suggestion here, just underneath the redacted box, is that while a proactive SO12 operation was put in place to trace and place the subject under control, the fact that the protest did not occur was entirely due to the SDS officer effectively talking his fellow activist out of this plan. This is at the 11th hour, when the person concerned had in fact constructed his vest and was fully intent on carrying out his plan. This report here doesn't seem to bear any correlation with the realities of what had happened, in that there was no vest that had been constructed, there was no intent on carrying out this plan. So the suggestion that an SO12 operation had managed to foil the supposed plan is almost fabrication. What can you help us with that, as to where this information came from to make its way into this intelligence report?
I can't help with where it's come from, but if I may comment, am I to assume that the person that says it was a joke may have a vested interest now after the event in saying that, and are we relying on that individual's assessment of what happened, or is there information to support the statement being made by the individual that it was all just a prank and it wasn't going to happen?
Well, the evidence has been given to the inquiry from...
That's all I'm saying, is that I'm being asked to condemn an
Not that the vest was already constructed. Are you able to assist us at all with that?
I'm not able to assist, and as I say, this would be the officer and the SB position, and you have the other position from the other individual. And all I would say is what the other individual is saying, is it supported by other information, or are we having to decide between the SB officer's interpretation and the individual who was the subject of reporting?
Do you recall this? I think you've said that you don't recall it at all. It wasn't hailed as a big success of the SDS, was it?
No, I can't recall it now.
Page 15, please. We can see here, in terms of the extreme left wing, the Socialist Workers' Party, Socialist Party mentioned here. And over the page we have individuals as well that I think are mentioned in the document. Some of the individuals that are named, particularly towards the end of paragraph 3.16, are and in 3.17 are CPs in this inquiry. Is it fair to say that you had some detailed understanding of the types of operations that had taken place in relation to these organisations and the people who are named within this document?
At the time when I was responsible for it, I would have had knowledge of it and could have found out further knowledge from sources previously mentioned.
So your knowledge wasn't limited at the time when you were in the position you were between 2002/3 up to 2005, but it's limited now, is it? Well,
yes,
at which you
it's
made your
limited
witness
now
statement.
because for historical reasons we're talking about 20 odd years ago.
Was there any reason to suggest in your witness statement that your knowledge was limited about SDS operations for any other reason other than the passage of time?
Yes.
Essentially, were you trying to distance yourself from the SDS?
No, I wasn't trying to distance myself from the SDS, but it is accurate to say I wasn't involved in selection, tasking of SDS officers. The SDS was a very small unit within a very large structure of special branch, and even within my areas of responsibility, there were quite a lot of other very, what could be regarded as important and strategic areas of business. The day-to-day management of SDS would have been done by DCI and the Superintendent S Squad. If I had wanted information about specific operations, I would have gone to them. But my day-to-day involvement with the SDS was limited, very limited.
There is a note behind tab B24 of a meeting that you had with the Op Hearn investigators in 2014, and that is MPS 07388090. And your evidence about that in your witness statement is that, well, this was a meeting that took place in the canteen and a note was taken of it. It wasn't a formal interview and I didn't have an opportunity to sign the notes or agree the written up typed version of the meeting. Do you recall that?
Yes, I do. I was invited to come and give some background information to Operation Hearn, and I went in, and that took place in the lounge area of the canteen with people sitting next to me reading books or doing knitting. And it was more of an informal discussion with one or two questions put to me by the officers concerned.
There's a couple of extracts I'd like to draw your attention to in this written up version of that meeting. The first is page 2, please. Under, in relation to the SDS, third paragraph, my understanding of the role was to disrupt from within. It's that reference, the disrupt from within, and you take issue with that, the use of that phrase in your witness statement. In terms of that, you suggest that the disrupt from within phrase was something used by Rod Leeming, and you recall him using that phrase. In terms of how that sits with SDS operations, did you have an understanding that SDS operatives would infiltrate a group and try and disrupt their activities?
No, I was quite surprised. It arose when I visited on one of my first visits to the NPIU, and I was told about their unit, the undercover unit that had been set up within Arnie when it was under Home Office control, and that the difference between their unit, which was to gather evidence, and that they were all National Undercover Course trained, and the SDS was that the SDS was there to disrupt from within. And the reason it stuck in my head is that I had never heard that description before. That was the first time that I had heard it used as a description by anybody as to what the potential role of the SDS was.
There's a document MPS 0526827. Which, if we go to the first page, we can see this is about Ring Wraith. So again, this is HN118 Simon Wellings and his disengagement. If we go to page 3, please. It's a file note from the 25th of August 2004. So during your tenure, it's a report by DCI Dell. And the last bullet point here is to consider with C Squad whether we should leave globalised resistance intact or, through RW, mount a destructive operation. Is that something that you understood could take place?
It seems very dramatic that you could do that with one organisation. I would have been very surprised, I must admit, if they were going to propose that.
On page 40, the note concludes that formal monthly presentations by Detective Superintendent Connell and me, Dell, to DCS Mitchell for review of the process of disengagement. So do you recall DCI Dell, DSU Connell briefing you in relation to that?
No, I have no recollection of that at all, I'm afraid.
So was there any suggestion at all to you that there may be opportunities to disrupt this organisation, or I think the decision was not to?
I have no recollection of that, and as I say, I would be rather surprised that they were going to suggest that at that time.
And you don't think there would have been capacity to be able to do that anyway?
It's a question not just about capacity, it's about legitimacy of doing it.
So was it not legitimate to even contemplate doing that? It wouldn't have been a proper use of undercover officers? Looking
at it now, I would like to think I would have been concerned at the time that what you have is an organisation which is a pain, but it's a rocky road to go to start disrupting organisations because they're a pain and to bring it to its knees. I don't think that would be necessarily what the role of Special Branch was then.
And when you say a pain, it's a pain for the police or for the government?
A pain in terms of public disorder or public order. I wouldn't want to speak to what the government regard as a pain or not, but it's a lot of these organisations potentially wither on the vine, and it's not a particularly good slope for police to start hastening them on their way.
Paragraph 8. Oh, sorry. Back to page 3, please. Sorry, can we go back to the Ophern meeting now? The other document, MPS 0738090. And page 3, please. Under the subheading incidents, there's a number of different incidents that you spoke about during this meeting with the Ophern investigators. And one of them was in relation to John Dines. You say, I knew of the problems surrounding John Dines. What did you know about Helen Steele's relationship with John Dines at this time later on? Because you've described her as her being a stalker. Was there any understanding on your part that in fact what she was responding to was John Dines continuing to contact her once he'd left his deployment in loving ways, but also suggesting that he was having a mental breakdown? So this wasn't a woman that was stalking a previous associate or anything like that. It was somebody that was trying to find out what had happened to a loved one.
No, I've no recollection of knowing that at all. Otherwise, I feel that I would have said that to the Operation Hearn officers as well. I wouldn't have just left it at that stage. So I wasn't aware of the full extent of what you've just told me.
You suggest at so was your understanding that there was no sexual relationship there? This was just a stalker, from what you had heard.
Again, what I'd heard was in passing at the time. It wasn't something that I was specifically involved with in discussions, and so I didn't really follow it up, and I didn't follow up or was aware of developments or what the conclusion was.
At page 6, please. Paragraph 5. You mentioned that the John Dines situation again. You say, I believe that the sexual relationship would not have been documented in the claim, as it would have needed approval from the MPA in order to get the amount of money necessary to relocate him. Talk of sex would have raised questions surrounding the normality of such an occurrence. In terms of that, is it your suggestion here that sex would have been dampened down effectively to protect him being able to get the money necessary to relocate?
It may well have been the case, yeah. It may well, at that time when I was speaking to Hearn, it may well have been on reflection to suggest that.
And would it similarly have been the case that any sex in relation to other officers may have been dampened down in order to protect the SDS or any other interests that either the office or the officers themselves had?
I would like to think it wouldn't be.
But in reality, is that likely?
I would like to think that the senior officers I worked with and the people I worked with wouldn't have been quite as cynical.
Was there a sense that by 2014, when you're giving this, having this meeting, that sex undercover was a normal occurrence, or more normal than you thought it had been?
By that time, the information that was coming out certainly suggested that it was more normal occurrence than I would have thought of at the time. So my views in 2014 would have been flavoured by the fact of what I was reading in the press and on the media, because of course by that time I was no longer a police officer.
Did you have any involvement at all in the relocation of Dines to Australia?
No.
Were you involved at all in the decision making around the payment for his relocation?
No, that would have been above my pay grade. The only thing I knew about his relocation to Australia was that one of the SDS managers had gone out, and I only knew that because he said he was off to Australia.
Was that HN53?
That's correct.
And what did you understand he was going to Australia for?
He was going to help relocate John Dines from New Zealand.
In terms of true spies, you address this at page 4 towards the bottom. Well, I say you address it. The note is that you spoke about this at the bottom of page 4 of this note. And you say, to my memory, there was only one segment of the programme that was edited effectively by SB, which was the part relating to Operation Sparkler, as it was believed to pose too much of a risk to the officer involved. We know that was Officer HN10. Was that the only issue that there was a discussion about?
What with the producers?
Yes, about editing it out, or discussion within
I
Special
wasn't
Branch.
involved in the actual setting up the programme. I was involved in looking at the potential illegality of the officers taking part.
And being careful not to breach any ROs, which you may not know exactly where the lines are, but was there any other discussion about any other operation that might have been edited out of the True Spies documentary?
From what I understand, the BBC retained all editorial control, and that was the only piece that was removed. That would be my understanding.
Was there any attempt by SB to redact anything else out?
I can't say because I wasn't involved with the producers at that stage. My involvement, because I would be a DCI working within another area of Special Branch at the time, my role was the potential investigation of offences by those that took part in it.
Finally, in relation to this document, page 6, please. In the first paragraph, you say the most successful officer I know of was EN32. That was an MPOIU officer, is that right? Should be
yes, it probably would be. Without looking through, I have a very good idea who that would be. Yeah, yes.
Sorry, that's an
Yes.
open officer, Rod Richardson. And he was deployed from 1998 to 2003 in the Reclaim the Streets, Wombles, Movement Against the Monarchy in the Sumac Centre. In relation to his deployment, were you aware that he had used a deceased child's identity for the reasons of legend building?
No, I wasn't. In 1998, the unit was part of Arnie, and it was an undercover unit part of Arnie, which was managed and run by the Home Office at the time. I only discovered that the officers used the dead baby names when the Operation Hern officers told me at the meeting in, I think, 2014, to which I was very surprised.
That was a practice that had pretty much ceased within the SDS around 1994, but we know that HN16 had used the practice again for his own purposes, and it was under investigation in relation to the use of that identity of Kevin Crossland. What comment do you have, if any, about the fact that EN32 in the MPOIU was also using an outdated form of legend building or providing cover in using such a inappropriate method?
Again, I can't speak for the organisation and the management in 1998 when he was put out into the field. To my mind, it raises all sorts of issues. Apart from the moral issue, there's also the operational security issue that you're using somebody else's name. Most of the NPIU officers had all done a national undercover course. Many of them were experienced, to my recollection, experienced undercover officers. To my mind, to use another name that wasn't supported by a legend could potentially bring operational security problems in the future if by some inadvertent accident they met somebody who they had been deployed in another name. And again, because they were managed or all trained centrally, I had always assumed that they would be given a legend and an identity that would move with them, whichever role they were pursuing, to avoid that operational security issue.
So while he was deployed during the time that you were responsible for the MPIU, that comes as a surprise to you, does it?
It does, it does. My assumption would have been, because they had all been trained on a national course, cover identities and identities would have been taken care of there, and that there would have been a structure in place for them.
So those are all the questions that I have. If we can take a break for Rule 10,
Yes.
please. And I'm sorry for the late hour.
Yes, I think before I rise to permit that to happen, Ms. Mannion, there is a topic that was very briefly covered this afternoon, but about which I understand the Metropolitan Police Commissioner and those who advise him is contemplating and considering whether or not further disclosure can be made. Am I right about that?
Yes, in respect to the case of TBS,
Yes.
a waiver of legal professional privilege.
Yes.
Yes, I can confirm that is under review at the moment. I'm so sorry.
No, of course, please do. You're quite right to point it out. Thank you.
Is this better?
Yes.
Yes, well, simply, sir, to confirm that the Commissioner is considering the waiver of LPP in respect of the TBS decision-making that happened in 2011.
Yes.
And that is under review at the moment.
A contemporaneous note to which the witness was not referred. He was referred to his own recollections about it, but a contemporaneous note has been redacted to eliminate legal advice given at the time, I believe.
Yes.
I haven't seen it, and I don't know what it says.
Certainly, sir, and that's included within that review.
Yes, thank you. Very well. I'll rise now for 10 minutes.
Yes.
For 10 minutes to deal with Rule 10.
So just one question, if I may, in relation to the authorisation of HN104 Carlos Saraki's deployment, and looking at his Reaper authorisations, please. MPS 0526932. If we go to the first page, we can see that this is Craggy Island's docket, which relates to 104 Carlos Saraki. Page 7 of that document, we can see that there is an authorisation signed off by you on the 2nd of August 2006. So it appears in 2006 you were still signing off SDS authorisations in place of the commander. So you were acting up as commander in 2006. Is that right, that although your tenure came to an end around the end of 2005, as we have you on the timeline, you were still signing SDS documents in 2006?
I can't remember specifically whether I was or not. This is one I signed, and in terms of the chronology of who was doing what, I may have been, but I can't remember signing many, if at all, other than, maybe one or two.
If we go to page 39 of the document, please. So we can see that Craggy Island continues to maintain access to the Socialist Party, the anti-fascist militant group Antifa, whilst continuing to carry out gradual extraction from the group. At the request of the Domestic Extremism Red Desk, Craggy Island has been able to provide up-to-date reporting on 2 prominent SP activists, as well as ongoing assessments of likely industrial action, particularly within the NHS and the public sector generally. And the question is about the legality or appropriateness of such reporting. Did you have a view on this when you were looking at his deployment?
I can't remember when I was looking at it. My assumption now, and probably at the time, would have been what he was looking at was not so much industrial action within the NHS as in general industrial action, but industrial action that may well be being orchestrated or encouraged and developed by groups that he was looking at. So not mainstream industrial action, but extreme left-wing political motivated action.
What would be the policing interest or value in knowing about industrial action within the NHS and other public sector bodies?
In terms of policing interest or knowledge, there might be peripheral interest in any public order events or any protest. But in terms of the broader interest, there may well have been interest from within government or the Home Office around militant activity being orchestrated within the NHS. But that's me looking at it now on this date. On the day, I may well have asked Frankie what it was about, and he may well have satisfied me, and it just wasn't reflected in the document. But that's all I can think of.
Can there be any justification for that sort of undercover reporting?
I think it's probably a very badly worded document. At the moment, I would say no, there probably isn't. Industrial action isn't really something that police should be looking at in terms of intelligence gathering, unless it's going to lead to crime, serious disorder, or other acts of criminality.
Who would be the customers of such reporting?
Well, the customers now or the customers then?
Then for these reports in 2006.
If it was in terms of orchestrating within the health service, it may well have gone to other government departments, depending on what the intelligence was that was being gathered and what it was saying.
What government departments?
The conduit for it would have been through another government agency.
Which is what?
Well, SDS would report occasionally to the Security Service, and that would be a conduit into government if it was felt appropriate. But again, I cannot say specifically in this case that's what happened.
Looking at this now in hindsight, would you accept that that was a completely inappropriate use of undercover policing?
Again, because I don't know what the actual rationale for them putting in within the NHS is, I wouldn't want to make a sweeping statement that that was the case without knowing the full background to why it was necessary. And unfortunately, I don't have that in front of me, and I can't assist on that.
So I have no further questions.
I've been told that the Security Service ceased to have any effective interest in groups of the sort that might have been involved in this type of activity. Their interest began to be lessened in very early 1990s and ceased in the mid-1990s. The suggestion that they would be interested in passing on this information to elements of government in 2006 is one that they might balk at.
Absolutely. Absolutely. I think I should clarify that if we wanted to get information, sir, into government or for any particular reason, that would normally be the conduit, unless it was Home Office.
But I don't, at the moment, begin to understand why an element of a police force would think it a requirement to communicate to any element of central government this sort of activity, this sort of intelligence. Can you help me?
Yes, if I could, sir, and I would go back to probably the year 2000, and having recently taken up with the NPIU at the time, you may recall that there was a fuel and farmers dispute. And my experience at the time was that within government, that was the biggest thing that had happened for decades within certain sections of the Home Office and government. And at that time, with the newly formed NPIU, there was a desire for lots of intelligence to be gathered, which we pushed back on. But at that time, there was certainly within sections of government a desire for intelligence, and not just in relation to undercover officers, but other areas of police intelligence gathering, which I think we felt was totally inappropriate. So there was an example of where there was a desire within certain sections of government for some of this sort of intelligence.
I think that's probably as far as we can take this issue today. Thank you for your attendance. I'm sorry you've had a long day, but I'm afraid that is by now traditional here, and witnesses such as yourself have to put up with it. I'm grateful for you for doing so.
Thanks,
Thank
sir.
you. We will resume it being Thursday today on Monday, will we not? At the usual hour of 10 o'clock. Yes.